Tracking this evening, high drama at the extraordinary general meeting called by a group of investors who own over 30% stake in crisis-hit edtech company Byju's. The investors are seeking to oust CEO Byju Ravindran and the board. Byju Ravindran chose to skip the meeting, calling it illegal. The EGM saw several disruptions with employees shouting slogans. Meanwhile, the investors have also moved the company law tribunal, seeking to oust Ravindran and the board. My colleague Ritu Singh is here with more details. Ritu.
Well, extraordinary drama at the extraordinary general meeting at Byju's this morning that ended earlier this afternoon. There was slogan calling by employees. There were impersonators pretending to be investors. A lot of uninvited attendees trying to join in the virtual EGM to disrupt the proceedings. But that aside, all 7 key resolutions that were to be put to vote have been put to vote. The EGM has ended, but we're still awaiting the results. The founders, Byju Ravindran, Divya Gokulnath, they skipped the meeting, calling it illegal. They said the group of shareholders calling for this EGM was in violation of the Articles of Association, the Shareholders Agreement, and the Companies Act. Meanwhile, you also have a group of investors led by Prozis, Speak 15, General Atlantic and others that have moved the Bengaluru bench of the NCLT, seeking to remove Byju Ravindran as the CEO and calling him misfit to lead the company. They also seek to revamp the board as proposed in the EGM and declare the recently concluded $200 million rights issue as invalid. Now, meanwhile, Byju's in its statement to us said that it had not received any such formal notice about this case being filed in the NCLT. But that aside, let's get back to the EGM, where of these 7 items on the agenda, the key, of course, was the removal of Byju Ravindran as the CEO, the removal of Divya Gokulnath and Ritu Ravindran from the boards, from their managerial positions as well, the formation of a new 9-member board, the appointment of a forensic auditor to look into the affairs of the company, the appointment of an interim CEO to take over the affairs, and then the enlistment of a search firm to find the next CEO, among others. Plenty of items on the agenda, but keep in mind, no matter what decision is taken by the shareholders today, and these are some critical big decisions we're talking about, they're still going to be subject to the Karnataka High Court hearing, where, Byju's has challenged this EGM as illegal. The next hearing there is on the 13th of March, and no resolutions can be given effect to until that next day, which is the 13th of March.
All right, Ritu, please stay on with us. We're also joined by Gopal Jain, senior lawyer at the Supreme Court, and J.N. Gupta, former executive director of SEBI and MD of Stakeholders Empowerment Services. Welcome, gentlemen. Thank you for your time and speaking to us. My first question is, and Ritu, my colleague, would also be asking you questions on this very big story that we are tracking. Mr. Jain, what do you make of the chaos that unfolded at the EGM today and Byju founders challenging the validity of this EGM?
Look, let's look at this in context. Investors and founders have played an important part in the whole startup ecosystem for which India is known all over the world. Now, if a majority of the investors totaling 30% who made significant investments have chosen to take a decision by calling an EGM, that's a matter of serious concern and an expression of vote of no confidence. Now, there is a forum in which all these issues are deliberated and discussed. So if one has a viewpoint, it can be expressed in this domestic forum, so as to put it. The reason for the chaos is if you stand out and rent a crowd, then there will be needless chaos. I think the best way of addressing such serious charges and violations which have taken place is to be there on the ground and answer it like the captain of a ship. You've got to be there, take charge and address this issue. Running away does not mean these issues will go away. That's point number 1. And second, as you rightly indicated, there are various forums where these issues can be raised. For example, in the NCLT, those are legal remedies which can be taken recourse to by investors and shareholders. And these grievances are then adjudicated in a competent court of law where the matter, as you said, has already landed. So that is the legal part. And third, the very signal and message which comes really shows serious issues of governance, financial mismanagement, and raises a larger issue of the moral right to continue when your major backers who've always been there for the founders, who've been founder friendly, if they have now chosen to take the step it must be a grave compulsion and of serious concern. So one must also look at the morality of it, the propriety of it in a situation of this extraordinary kind, especially when India is leading the G20, is seen as a leader in the startup world. We must send very clear signals of good governance and to show that investors' investments and sentiments are held intact. So that is how I would address what you put to me.
Mr. Gopal Jain, just taking that forward again, the captain of the ship should have been there to address these concerns, like was just being pointed out. But what recourse do you think the founders now have if a group of shareholders accounting for more than 30% of the shareholding in the company have called for this EGM, and let's say these resolutions are passed? What is the recourse for the founders in this case?
No, so in case somebody is aggrieved, then you can move the NCLT as example of there's a pending proceeding in the High Court. You can raise these issues in the competent court where these issues are pending or where you can raise these issues. So legal remedies are always provided under the statute itself. But I think the first thing is when there's a meeting which has been called and issues are being concerned issues are being raised and deliberated, the first thing is to participate and answer and clear the air. I think that's the first and most important thing, to come clean, show there is transparency, show there's governance, and show that the reasons by which such decisions had in fact been taken. Provide justification, provide material, come clean, so that you can have a frank discussion and allay apprehensions if they are in fact just apprehensions.
Mr. Jain Gupta, we had heard the founders call this EGM itself illegal. They say it violates the Companies Act and it violates the Articles of Agreement, the shareholder agreement of the company. Given that it has representation from some of the biggest investors in support of the others, can this be argued in court that, the founders and the board members not being present makes this EGM illegal at any level?
See, I will go one by one. The first is this: in governance, it is not the form, but the substance is important. So we very clearly agree that the governance is a big issue in BYJUS as on date. So it is the duty of all concerned, whether it is the promoters, founders, directors, or shareholders, to come to a situation where they should deal it together and improve the governance. That is one part. The second part is this: with 30% of the investors calling EGM, at the most you may say that the notice was not proper, something about a comma was missing, full stop was missing, but at the end they are 30% shareholder, much more than the 10% required, and the matter is already in NCLT. Now, by boycotting the EGM, the founders have lost the chance to present their view. And in the situation where the resolutions are carried and NCLT doesn't find any problem with this thing, then they would have lost this opportunity permanently. But then they will move to High Court and then Supreme Court, and the matter will drag on. So my first issue would be, all such matters should be treated by ICU cases by the courts, and justice should be doled out in days, or if not weeks, but certainly not years. That is second point. Third point that I want to make, and that is very important for the startup ecosystem. At SEBI, whenever I am attending some meeting, so there is a general tendency to say that startups or the technical founders are weak in legal matters and governance, so they should have a diluted governance norm, which I find very amusing. For the simple reason, if a doctor finds somebody weak on some vitamins or minerals, they give a supplement. So it is all the more reasons for startups or technical founders should have an enhanced governance norms, so that there is no problem like this. The problem in ecosystem is this: either the failure is there, or if the success is there, success is so fast and so soon that people go haywire from their core business. And in this BYJUS case, as you have seen, the valuation has dropped from X to Y, and the difference is between North and South. So I would say one very simple
Yes, sir.
governance is important, and governance should not be seen in only the form that the notice is not proper or full stop is missing, but in the substance. And the substance is that today there is a big governance vacuum at Byju.
Well, no doubt, Mr. Gupta, governance is of utmost importance. Just a final question to you, sir, before we wrap this up. Do you think, irrespective of the outcome of the EGM, the fact that investors have already moved the NCLT to declare the founder unfit, to change the board, will the action completely shift there? And, you know, that really doesn't matter what happens at the EGM at the end of the day.
The question is to me or to Mr. Jain?
Mr. Gupta.
Yeah, okay. So again, I am saying that the investors have moved into two parallel things. One is they have called EGM, and then they have moved to NCLT for this. And NCLT is free to decide on the application within the framework of the law. But I am saying that either way, it is going to be a loss situation for promoters, because they have backed out at this juncture and they have not participated, calling things illegal where their own conduct has been under question.
All right. Thank you so much, Ritu, Mr. Gopal Jain and JN Gupta, for that comprehensive update and analysis of this big story that we are tracking on CNBC-TV18. It's time for a short break, but coming up next, a budget announcement mandating a 45-day payment cycle for MSMEs has the industry worried. More details when we return.